The Colorado Supreme Court on Tuesday declared former President Donald Trump ineligible for the White House under the U.S. Constitution insurrection clause and removed him from the state presidential primary ballot, setting up like a showdown in the nation's highest court to decide whether the front-runner for the GOP nomination can remain in race. The decision from a court whose justices were all appointed by a Democratic governors marked the first time in history that Section 3 of the 14th Amendment has been used to disqualify a presidential candidate. A majority of the courts told that Trump is disqualified from holding the office of the president under Section 3 of the 14th Amendment, the court wrote in its 4-3 decision. Colorado highest court overturned a ruling from a district court judge who found that Trump indicted an insurrection for his role in January 6, 2020 attack on the Capitol, but said he could not be barred from the ballot because it was unclear that the provision was intended to cover the presidency. The court stay in decision until January 4 or until the U.S. Supreme Court rules on the case. We do not reach this conscience lightly, wrote the court's majority. We are mindful of the magnitude and the weight of the questions now before us. We are likewise mindful of our solemn duty to apply at the law, without the fear of favor and without being swayed by a public reaction to the decision that the law mandates we reach. Trump attorneys had promised to appeal any disqualification immediately to the nation's highest court, which has the final say about the constitutional matters. His campaign said it was working on the response to the ruling. Trump lost Colorado by 13 percentage point in 2020, but that does not need the state to win the next year presidential election. But the danger of the former president is that more courts and election officials will follow Colorado lead and exclude Trump from must-win state. Colorado officially said that the issue must be settled by January 5, the deadline for the state to print its presidential primary ballots. Dozens of lawsuits have been filed nationally to disqualify Trump under Section 3, which was designed to keep former Confederates from returning to government after the Civil War. It barred from office anyone who swore an oath to support the Constitution and then engaged in insurrection or rebellion against it, and has been used only by a handful of times since the decade after the Civil War. The Colorado case is the first where the plaintiffs succeeded. After a week-long hearing in November, District Judge Sarah B. Wallace found that Trump indeed had engaged in insurrection by indicting the January 6 attack on the Capitol, and her ruling that kept him on the ballot was a fairly technical one. Trump attorney convinced Wallace that because the language in Section 3 referred to the officer of the United States who taken an oath to support an institution but must not apply to the president, who is not included as an officer of the United States, as well in the document whose oath is preserved, protect, and defend the Constitution.